10 minutes. Garmila Magad Corla, and I welcome this opportunity to participate in the debate, and I would like to think it's the start of a bright light shining on the opaqueness of our appointment system in relation to the judiciary. I want to say from the outset, Minister, I believe you've been handed a hospital pass, and that phrase has already been used by Deputy Murphy, and in a previous life, while we were delighted to get a hospital pass as a barrister, we knew exactly what it meant, and I think that's what's landed on your lap is a hospital pass. It's regrettable that it has taken this much effort to have this limited debate in this manner, and I put the blame squarely on the Taoiseach. I'm afraid he has learned nothing. And earlier this week we were looking at the lobbying bill brought forward by Sinn Féin, and again I stood there and I had read the SIPO reports, and I asked myself, why have we to rely on opposition, and fair play to Sinn Féin for bringing it, to bring changes? And so SIPO had told us repeatedly what changes were needed, and yet in January of this year the former Minister for Public Expenditure told us no changes were necessary. And so it took all of the scandals to date, the revolving door, plus the initiative from Sinn Féin to force some type of change. And even then the government said we need 9 months. Now similarly with this, why do I mention that? Because I looked back, and I want to thank the media actually, some parts of the media in relation to this story, because without them we would have very little information. And certainly we'd have none if we were aligned on the government, because what the government have told us, they have done nothing wrong and they've complied with the procedures, and the procedures been totally opaque because nobody knows how they work. And so if I look at the former Chief Justice Susan Denham, when she left and retired in 2017, and among very many interesting things that she said in her farewell speech, she talked about the lacuna that were there and the necessity for change. And she said the lacuna is there in spite of many years of discussion. She first discussed the matter back in 1997 with Nora Owen, and what was needed in terms of legislation, training for judges, a more transparent a system for appointments, and so on. She also referred to the eyes of the Council of Europe, GRECO, which has been referred to many times. And in 2007, she referred to a report from GRECO, which was 2014, which made 5 recommendations: that a judicial council be established, that the system for appointing judges be reviewed, that a special pay and conditions body be established for the judiciary, that a code of conduct for judges be formally established, that a dedicated training institution for judges be established. And she said in 2017, notwithstanding that those recommendations had been made by the Council of Europe, or the body acting under their aegis, not one single recommendation had been acted upon, and this was the judiciary asking for change. GRECO have continued to publish interim compliance reports amongst other reports, and they are still not happy with the rate of change in Ireland. Now, I disagree with the comments of Deputy Smith, and mostly I agree with her, but I think it's remarkable that the judiciary have been independent. And indeed, I remember Justice Niall McCarthy, deceased, and he stands out and tried to hold the government to account in relation to the amendment in the Constitution in relation to the abortion referendum and so on. And also Peter Kelly, amongst many other judges. Now, I'm not here to make any apologies for judges, but it's remarkable their independence. And in my moments of despair with this institution here, and with the health executive and many other institutions, the judiciary stand out as the last bastion for an ordinary person on occasions. The biggest problem, of course, is that most people don't have access to the courts because it's way too expensive. And I wish that's what we were talking about today. In relation to your speech today, I would call it disjunctive. I don't think the paragraphs follow from each other, and again, I think you're in a very difficult position. I think the Taoiseach should be in here answering these questions today and setting out what has happened. He was well able to speak when, on the last occasion, Fine Gael and Labour allowed the then Attorney General to go to the Court of Appeal, and he called it an insider job that stunk to high heavens. I take that back. At that point when it went up, his comment was that it stuck to high heavens. I'm not here to score political points. What I'm here to outline is that each government has absolutely failed to learn that we need to change the process in relation to appointment of judges so that it's not opaque. If I stay with Justice Denham for the moment, she said, paying tribute to the media, she said, "I would like to thank the journalists who have reported on the work of the Supreme Court during my tenure as a judge of the court and as Chief Justice. And this is what's significant for me. For the rule of law to flourish in a democracy, an understanding and knowledge of what happens in our court is required." And I would add to that and say, for democracy to flourish, what we need is a knowledge of how institutions work, and particularly governments and the executive, and how they appoint judges. And it seems to me that there's no openness and accountability at all in your speech today, nor in the manner in which the former Attorney General was made a judge of the Supreme Court. I have no wish to comment on the merits or otherwise of that appointment. I'm commenting on the process. It seems to me extraordinary that one of your paragraphs refers to the fact that it was practice to leave a Supreme Court vacancy. I find that extraordinary when we have a Chief Justice writing in February to urgently fill the appointment. We seem to have many parallel systems of appointment. Remember, back in 1995, the Act was brought in to bring some measure of reform to the appointment system. That jab through which the former Attorney General went was one point. Then we have judges who are interested, and they send their expressions of interest through the Attorney General or the Minister for Justice. You haven't clarified here today. Is it the Minister for Justice that receives those expressions of interest from the sitting judges, or is it the Attorney General? And if it's the Attorney General, has anyone asked, is there a conflict of interest from any Attorney General that's sitting as Attorney General, wants to become Supreme Court on this hand, and on this hand he has the applications from the sitting judges who are interested? Has anyone thought about that, or how that conflict is handled if there is a conflict? Certainly, in my opinion, it has all the appearances of a conflict. You haven't dealt with that whatsoever. And then there's the third system where we have judges who are there but they haven't come forward, but the government is allowed to consider those. What is the procedure for looking at that? Does it not strike you that we, as a republic and a democracy, that is not open and accountable? That's not an open and accountable system. And we can't call ourselves a republic and a functioning democracy if we don't have an open system. Following the debacle in relation to the previous Attorney General being appointed to the court, and again, absolutely no comment on the person, just what happened. Following that, and Deputy Howlin himself has referred to this, I understand there was a review by Martin Fraser. And following that review, a committee was set up parallel with the jab situation, and this committee was made up of the Chief Justice, a layperson, and other distinguished people. We're not aware who or how they were appointed, how they functioned, but it seems to have functioned well, and it seems to have been instrumental in appointing a number of applicants to the higher courts. And where did that go, Minister? Were you told about that? Where did that system go? That's a kind of a fourth part of the jigsaw now. The jab, the notices going straight to the Attorney General or to the Minister, nobody's clarified that. Then the sitting judges that the government can pick. And then this advisory committee that was set up following the previous debacle, in relation to which Micheál Martin said it stunk to high heaven. What happened to that setup? Now, it would be helpful if that was outlined to us today. It would be helpful if you were here today saying, we cannot stand over this system anymore. This is the way it was always done, but it can't go on like that, because Number one, we're in trouble in Europe because we're pointing the finger at other countries, and rightly so, but we need to look in the mirror first. We need to look at what the Council of Europe, through their organisation, Greco, have highlighted repeatedly. And I'll finish up by saying the irony, of course, of all of this is the fact that we don't have a system in place yet in relation to complaints about judges' behaviour. And so a lot of the information we have here is by default, because we didn't set up a system, a fair and just system for complaints in relation to judges, as happened in relation to the former Attorney General, who's now Supreme Court Judge, Seamus Wolfe, and his attendance at Golfgate. We had no procedure in place to deal with that, so we go back to the former Chief Justice, set up an informal system, and a total mess ensues in relation to that. But we learn from the openness and accountability of when they printed the transcript, certain facts in relation to how Seamus Wolfe was appointed. That's ironic in itself. I hope it's the start of stronger light, and I hope it's the start of reform.
Thank you very much, Deputy Connolly. Now,